I'm Ben Meiselas from the MeidasTouch Network. The Second Circuit Court of Appeals has issued a very important ruling that is not going to make MAGA Republican Jim Jordan and the other MAGA Republicans in the House of Representatives happy at all. And the Second Circuit Court of Appeals issued a stay on a lower federal court's order, which temporarily pauses the requirement that Mark Pomerantz, a former assistant special district attorney, testify before the House Judiciary Committee pursuant to a subpoena that was sent out by MAGA Republican Jim Jordan and the MAGA Republican-controlled Judiciary Committee. You'll remember that the MAGA Republicans have continued, in the House of Representatives especially, have continued to try to interfere first with the Manhattan District Attorney Office's criminal investigation into Donald Trump. And now that Manhattan District Attorney Alvin Bragg has filed criminal charges against Donald Trump, the House Judiciary Committee, again controlled by MAGA Republicans, have tried to interfere with the criminal case against Donald Trump brought by the Manhattan District Attorney's Office. Now, one of the ways they've tried to interfere is by sending these subpoenas out to the Manhattan District Attorney's Office. And the most imminent subpoena return date, and this is why a lawsuit had to be filed by Manhattan District Attorney Alvin Bragg against Jim Jordan and the MAGA Republican-controlled Judiciary Committee, is that Mark Pomerantz, a former special assistant district attorney, was set to have his deposition taken pursuant to a subpoena on April 20th, 2023. So it was an imminent deposition that was scheduled. And the Manhattan District Attorney's Office argued there is no legitimate legislative purpose for the federal government, for the House of Representatives, to conduct depositions of former or current employees of the District Attorney's Office in furtherance of trying to interfere with a criminal case that is being pursued. Law and order, specifically state and local prosecutions, are under the umbrella of state sovereignty. You MAGA Republicans, remember when you were talking about states' rights, this? Yeah. The House of Representatives can't interfere on a case-by-case basis if they don't like the way a state or local prosecution is taking place, and they can't invade things like grand jury secrecy and the confidential communications of the Manhattan District Attorney's Office. These were the arguments made by Manhattan District Attorney Alvin Bragg, first in letters that went back and forth with Jim Jordan and the Judiciary Committee. And finally, when Jim Jordan said, no, we're keeping this subpoena of Mark Pomerantz on calendar, Manhattan District Attorney Alvin Bragg had to file this federal lawsuit. Unfortunately for the Manhattan District Attorney's Office, they drew a judge. The selection of these judges is random about which judge you're going to get. But he filed this case in the Southern District of New York, the federal court that has jurisdiction over this matter. And they drew a judge appointed by Donald Trump, federal judge Mary Kay Viscasil. And when I saw that that judge was assigned, I knew right away that Manhattan District Attorney Alvin Bragg was not going to win his lawsuit. And sure enough, federal judge Viscasil made a ruling on Wednesday of this week that Jim Jordan had a valid legislative purpose for hauling in Mark Pomerantz and potentially even seeking other individuals to depose within the Manhattan District Attorney's Office and to get testimony from. And what Judge Viscasil said in her order is that the valid legislative purpose is, one, there are sometimes federal forfeiture funds that are shared with states. And so here, in connection with the criminal case against Donald Trump, I think the Manhattan District Attorney's Office stated, look, I think maybe about $5,000 of federal forfeiture funds may have been used. And so just so you know, a federal forfeiture funds is when someone is charged with a crime and they've made all of this money based on their criminal conduct. The federal government can seize that. And then there's a sharing arrangement with states depending on, where the person was arrested or which task forces were responsible for the arrest. So the judge said, well, if federal funds had something involved in it, then surely the House of Representatives, that could be a legitimate legislative purpose, as Jim Jordan's arguing to me. And the other thing that Jim Jordan argued that the court accepted, even though the court says in the first page of her order, no one is above the law. And the court's referring to Mark Pomerantz. Like, Pomerantz, you have to testify in Manhattan District Attorney's Office. You think you're above the law. But one of the justifications about why the House of Representatives is involved, and I'm not making this up, this is specifically the federal justification that that Jim Jordan gave about why the Judiciary Committee is involved, is that the MAGA Republicans in the House of Representatives want to pass a law to provide complete immunity, to provide total immunity to former presidents who are criminally prosecuted. They want to pass a law on that. A law like that would be entirely unconstitutional because no one is above the law. But the court said, well, if that is a justification that they want to pass a law, then there is some hook here. There is some legitimate, valid legislative purpose. And so we're not going to, it's not my job as a federal judge to scrutinize whether that purpose is real or whether they're just making up that purpose in order to interfere with the Manhattan District Attorney's efforts to prosecute Donald Trump. The court also said, I don't really think there's a there's an issue of state sovereignty here. And then finally, the court said, the privileges that may be asserted by Mark Pomerantz, assuming Pomerantz hasn't waived his privileges, and I'll get to that in a moment. Pomerantz, when he is deposed or when he gives testimony before the Judiciary Committee, he doesn't have to answer all of the questions. If there are questions that touch upon grand jury secrecy or other confidential information that takes place within the Manhattan District Attorney's Office that he cannot answer due to privileges being asserted by the Manhattan District Attorney's Office, he could simply say, I'm declining to answer because of this privilege or because of that privilege, because of grand jury secrecy, because of other confidential criminal investigation privileges. And so the court said, that this court is not saying that you've waived necessarily your privilege. Assert your privileges, and then we could have a discussion about whether or not you've waived your privileges or whether you're validly asserting them.
Let's take a quick break to talk about our next partner, ZBiotics. Now, if you're like me, you've probably skipped a workout because of drinks the night before. It happens. But if you're committed to your healthy routine, you need ZBiotics. ZBiotics Pre-Alcohol Probiotic is the world's first genetically engineered probiotic. It was invented by PhD scientists to tackle rough mornings after drinking. Here's how it works. When you drink, alcohol gets converted into a toxic byproduct in the gut. It's this byproduct, not dehydration, that's to blame for your rough next day. ZBiotics produces an enzyme to break this byproduct down. It's designed to work like your liver, but in your gut where you need it most. Just remember to drink ZBiotics before drinking alcohol, drink responsibly, and get a good night's sleep to feel your best tomorrow. Now, I can't lie, after we hit 1 million subscribers, I may have partied a little bit too much that night. But luckily, I knew I had ZBiotics. Now, as instructed, I drank a bottle of ZBiotics before any alcohol, and I was amazed at just how good I felt the next day. Give ZBiotics a try for yourself. Go to zbiotics.com/Meidas to get 15% off your first order when you use Meidas at checkout. ZBiotics is backed with a 100% money-back guarantee. So if you're unsatisfied for any reason, they'll refund your money, no questions asked. Remember, head to zbiotics.com/Meidas and use the code Meidas at checkout for 15% off. Thank you, ZBiotics, for sponsoring this episode.
But the court said you may have actually waived your privileges, Mark Pomerantz, because you did write a book on this and you put a lot of this information in a book. You published it publicly. So you kind of put yourself out there and now you kind of reap what you sow. And this is partially your fault for writing this book. And the Manhattan District Attorney's Office point is we didn't authorize, Pomerantz to write this book, and we're the ones who hold the privilege. So if he engaged in misconduct, he's the one who put himself in this situation, but he's not allowed to waive privileges for our office. And just to remind you of the Pomerantz book and why he wrote the book, Pomerantz was a special assistant district attorney under Cy Vance, when Cy Vance was the Manhattan district attorney. Then Cy Vance's term ended. Alvin Bragg won the race for Manhattan district attorney, and Alvin Bragg wanted to pursue the criminal investigations of Donald Trump at a different pace. So the Manhattan district attorney under Alvin Bragg first successfully criminally prosecuted the Trump organization on I think it was 17 felony counts in under 9 or 10 hours. The jury reached a verdict on all of those 17 felony counts. So the Trump organization's a felon. The next priority the Manhattan District Attorney's Office had was the falsification of business records case, where Donald Trump paid hush money payments to Stormy Daniels in connection with the 2016 election and called them legal expenses. But the Manhattan District Attorney's Office said, we're going to do this falsification case, which they charged Donald Trump, but we're not quite ready to pursue charges against Donald Trump for his financial fraudulent valuations, which is what is the subject of a civil case by the New York Attorney General's office, Letitia James's office. That's set for trial October 2nd, 2023, right? So you have a civil case by the New York Attorney General, Letitia James, on financial fraudulent valuations. The Manhattan District Attorney said, we're not ready to do that criminal case yet. Let the New York AG do the civil case. We'll do a criminal case on the falsification of business records, and then we'll still do the investigation of Donald Trump regarding his financial fraud. We're just going to sequence it: Trump org, falsification of business records, then broader financial fraud investigation, and those charges potentially could be brought later. That made Mark Pomerantz upset. Pomerantz thought that the falsification of business records Stormy Daniels case was not as strong, and that the financial fraud case of Donald Trump was ready to go and wanted to bring that immediately. And Pomerantz said, why are we delaying this one? So Pomerantz resigned because he didn't like the order that Alvin Bragg went in, and then wrote a book about it. And that book was very public, did a media tour. And so one of the things that federal Judge Viscasel says in her order is he did a book tour. I don't know why he did a book tour. He's a smart lawyer, but he should now have to answer questions before the Judiciary Committee. And the Manhattan District Attorney's Office is like, yeah, he may have violated the law when he did that book tour, but he can't waive the privileges and confidences that we have in our office. Another point I want to make, though, and I think this is an important one regarding Alvin Bragg's timeline about how Alvin Bragg has pursued these various investigations. You'll recall from another report we did here at the MeidasTouch Network that the New York Attorney General Letitia James deposed Trump last week. And in her deposition, Donald Trump spent 7 hours answering deposition questions, and then even made a post on his social media platform after, saying, my company's so valuable, it's even more valuable than what I put in the statement of then he said the so-called statement of financials, which are the statement of financial conditions. And the whole civil case brought by the New York Attorney General is that Donald Trump was inflating and deflating these the values of his properties on his statement of financial conditions to try to get favorable lending terms, to pay less in taxes, and to get favorable terms from insurers. So it seems like Donald Trump may have further incriminated himself in this deposition. And the fact that the Manhattan District Attorney's Office sequenced it this way so as to not interfere with the New York Attorney General's civil case and to not interfere with Letitia James's deposition of Donald Trump, because now you have all that wealth of information from Trump's deposition, which can now be used in the potential criminal case regarding the broader financial fraud crimes that the Manhattan District Attorney Alvin Bragg could indeed charge Donald Trump with. So I really do think that Mark Pomerantz has been very short-sighted, though, in resigning. And while Pomerantz may have been right that those financial fraud crimes are more serious and could have been ready, the fact that Manhattan District Attorney Alvin Bragg waited has now allowed him to get all that information from Trump's deposition taken by the New York Attorney General, which Bragg's office would never have gotten. It would have made the case a lot weaker. So the case is now much, much stronger because of Manhattan District Attorney Alvin Bragg's strategizing here. So just to close the loop, though, on everything in terms of where we go next, right? So lower court, federal judge in New York. There's a federal court. There's different districts. So the Southern District of New York, the judge is federal judge Mary Kay Viscasel. She makes a ruling that Mark Pomerantz, you need to testify, show up on April 20th. The Court of Appeals, the Second Circuit, which oversees New York federal courts, it's the higher level court. They then say, pause. We need to look at this. Don't take that testimony yet. Don't take a deposition yet of Pomerantz. Submit us briefs. We want to hear briefs from the Manhattan District Attorney. We want to hear briefs from Jim Jordan and the House Judiciary Committee. And then we're going to review what the lower court did. We'll make the decision. And then depending on that ruling, the parties may appeal to the United States Supreme Court. So we will keep you posted on all of the steps, but that is everything that is happening right now in Alvin Bragg's lawsuit against Jim Jordan. We'll keep you posted here, of course, on the MeidasTouch Network. I'm Ben Meiselas. Hit subscribe. We're on our way to 1.5 million subscribers, thanks to your incredible support. It's free to subscribe to our YouTube channel. So if you haven't yet subscribed and you like news like this, please hit subscribe. Check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. And also wherever you get your audio podcast, just search MeidasTouch podcast as well and download that there. All right. Hit subscribe on our YouTube. It's free. Thanks so much for watching. I'm Ben Meiselas. Have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.